All right, hi again. Welcome back, Attorney Steve Honor, and welcome to another exciting video. Today we are talking about objections, depositions, the most common objections you will hear or raise in a deposition. So you're kind of familiar with these before you go in. So if you hear these things, at least you have an understanding of what it is. So without further ado, let's head to the Attorney Steve litigation whiteboard. All right, here we are. We're back. All right. So I have put up here what I believe to be the 10 most common objections that you will hear. There's others, but these are the main ones you're always going to hear. Let's take a look here. Number one, calls for a legal conclusion. Okay, when you're examining a lay witness, somebody who is not an expert, they're not lawyers, so you can't ask questions that are basically forcing them to give you some sort of legal conclusion. They're not lawyers. That's improper. That's ground for an objection. Okay? Next, privileged. Privilege, if somebody says, well, what did your lawyer say to you? That's privilege. You have attorney-client privilege. Or what did you say to your wife after you hid the murder weapon? That's privilege, husband and wife, spousal communication. So you make these objections to preserve it for the record. Now, lots of times in a deposition, your client is going to, you're going to just instruct your witness to go ahead and answer the question, but you make your objection. Some things you will not. If they want attorney-client privileged, I'm not going to let my client answer anything that has attorney-client content to it, okay? V&A, vague and ambiguous. Objection, that's vague and ambiguous. What does it even mean? I'm not sure what you're asking. Can you rephrase the question, please, so perhaps we all have an understanding? Or vague as to time, place, all those kinds of things. Next, irrelevant. Discovery needs to be reasonably calculated to produce evidence critical to your case, okay? Likely to be admissible evidence in the discovery process. So if it's some random question, hey, how many times did you cheat on your wife over there? We're talking about a totally different case over here. Objection, it's irrelevant. Move on, counsel, move on. Next is argumentative. Okay, this is where the opposing counsel is getting in the face. Now, he doesn't have to physically, or he or she doesn't have to physically get in the face, but it's arguing with the witness, giving your own opinions or your own conclusions instead of just asking a question. Okay, the deposition process is designed to ask questions to ferret out facts, dates, times, places, witnesses, evidence, okay? If you're being argumentative, objection, argumentative, counsel, tone it down. Can we just ask a question, please? Thank you. Next, narrative. Calls for a narrative. Hey, tell me everything that happened when you got home at 12 o'clock in the afternoon. Go. No. Objection. Calls for a narrative response. Ask one question, get one answer. That's how the deposition process goes. Next, speculation. Calls for speculation. Why do you think the New York Jets lost the playoff? Well, nobody knows. Who knows? Could be lots of reasons. Calls for speculation. We don't want speculation. We don't want guessing in depositions. We want testimony as to facts personally observed or believed to be true. So speculation, objection. Next, misstating testimony. This is a common one. An attorney will say, hey, well, so when you went and punched out the bartender, wait a second, that misstates the evidence. That's not what he said. Ask a question that doesn't misstate the evidence. Thank you. Objection. Next, compound questions. Tell me where you were born and what high school degree did you get? What college degree did you get? Tell me this and tell me that. Tell me this, that, and this. It's a two-part question. It's compound. One question, one answer, okay? Objection, compound. Next, finally, number 10 on my list, asked and answered. This pops up a lot too, where the attorney's asking questions and they're saying, well, tell me, why did you rob the bank? He already answered he didn't rob the bank. Stop asking the same question over and over and over again. That's called objection, asked and answered. So these are the 10 most common that you'll find in the deposition setting. So I hope that's a quick little handy guide to refresh you before you go in for a deposition. And again, usually the attorney will make the objection and then you will typically answer the question. That's how depositions go. But there are going to be some cases where you're just not going to let your client answer because it's privilege. It doesn't make sense. It's not within the confines of reasonable discovery. Okay, Attorney Steve Vondran, hope you've enjoyed this. This is general legal information only, not legal advice. Sometimes in a case you will just object to the form of the question, and some jurisdictions you need to be very specific about your objections. So sometimes in a deposition you may say, objection calls for a legal conclusion, argumentative, compound. So you might do several at once. Some jurisdictions say, hey, just object to the form of the question. That's fine. Covers everything. Okay. Anyway, thank you for watching. Attorney Steve Vondran. Have a great week. We will be back. Make sure I've got some great videos coming up. So we will be back. Thanks a lot. Bye now.